Today's video is called HOA Built a Road Through My Ranch, then Sued Me for Blocking It. This is going to be one wild ride. So buckle up, grab a snack, and get ready. If this story hit you like it hit me, don't just scroll. Subscribe for more true drama behind the picket fences. The story starts with our homeowner here in Colorado who decided that he wanted to build a house on his property. He had what's called an acre of land out in the country. There was no roads leading up to his property. So before he built his house, he had a road constructed so he could drive right up to it. The problem is, though, he didn't pull any permits for this road. I guess he thought everything was gone. Nah, it'd be fine, because he went ahead and built his house. Fast forward a few years and the HOA shows up at his door, and they tell him that they were suing him because he blocked access to their private road. You heard that right. Even though he was the one who built the road, he's now being sued by the HOA for blocking it. Wait, how can this be possible? How can the HOA own a road that he built, and how can he be blocking it when he owns the road? What the heck is going on here? Well, let me explain it to you. In Colorado, homeowners associations are created through a process known as a plat. Now, I'm not going to get into all the details about plats, because this video will probably be an hour long. But suffice it to say that in order for somebody to own property in a subdivision, there needs to be a plat in place. A plat is basically a document which creates a subdivision, creates blocks and lots, and it allows people to buy and sell and transfer property within that subdivision. In order for a plat to be valid, it has to contain things like dedications for streets and roads. If a developer doesn't want to actually physically construct a street or a road, then they can put down on paper that they dedicate this piece of property as a roadway, but it doesn't have to be built yet. It can just be put down on paper. So that's exactly what happened here. The plat for this neighborhood contained a roadway, but it wasn't actually built. Now, the tricky part about this is that when the plat goes on record, that roadway actually becomes property of the public. Even though it hasn't been built yet, it still belongs to the public, and this means that the HOA owns it and also maintains it. They're responsible for plowing it in the winter, making sure that it's safe for travel. So this homeowner knew all this, but he went ahead and built his road anyway. He figured that it would be okay if he built his own road and just connected it up to the dedicated roadway. That was owned by the HOA. But he did something very important. He put in culverts to block water from traveling underneath his road. That way the water had nowhere to go. So it started collecting on his property. This became a big problem for him in the wintertime, because he had large ice dams forming that were backing up onto the HOA's roadway. So after several complaints from neighbors, the HOA finally decided enough was enough. They brought him into court and they sued him for blocking their road. Let's take a look at the lawsuit. Here we can see that the HOA is seeking for our homeowner here to be forced to construct a bridge over the road so that water can pass underneath it. They also want him to remove the culverts that he installed, and they want him to pay for all the attorney fees and costs associated with this case. Now, I'm not going to get into all the technicalities about the law, but the HOA is basically saying that our homeowner here violated the terms of the plat, and therefore he should be forced to fix the issue. Our homeowner says that he shouldn't have to do anything because the road is actually his, and he has legal title to it. So he took the HOA to court. The HOA won at the trial court level, but our homeowner here appealed it. He said that the judge made a mistake when he ruled against him. Let's take a look at what the appellate court said about this case. They started off by stating that under Colorado law, an owner of real property has an absolute right to build a structure on his or her land unless there is a restriction on it. They state that in this case, there was no restriction preventing our homeowner from building the road on his property. Therefore, he had every right to build the road on his own property. But here's where things get tricky. They state that even though he had every right to build the road on his own property, he can't connect it to a public road. They write that it's well established in Colorado that if a person builds a structure on their property, such as a driveway or a road, they can't connect it to the public roadway. Think of this like having your own private road on your property. You can have that. But if you want to use the public road, you need permission from the local government. Otherwise, you're trespassing.
Ow.
So they essentially said that our homeowner here committed trespass by connecting his road to the HOA's road. He tried to argue that he should be held to this rule because he actually constructed the road. But the court said that this rule applies even if he built the road. The court stated, We recognize the hardship that may result from requiring an abutter to disconnect his or her private improvements from a public road. However, the General Assembly has determined that the public interest in maintaining the integrity of the dedication system, as well as the public road system as a whole, outweighs any hardship on an individual property owner. This means that our homeowner here lost his appeal. He was found to be trespassing by connecting his road to the HOA's road. Because of this, he was ordered to pay for all the costs of installing a bridge. He was also ordered to pay for the increased cost of maintaining the bridge, and he was ordered to pay for all the HOA's attorney fees. It's worth noting that the HOA here was actually asking for quite a bit. They originally asked for $400,000 to install the bridge, but the court only awarded $235,000 to them. And they also asked for $180,000 in attorney fees, but the court reduced that down to $75,000. I think this case is so interesting because it deals with some really obscure rules about roads and how they remaintained and who is responsible for them. But the real lesson here is to make sure that you do unmess with the HOA, because even if you read technically in the right, they will fight you until the end, and they will make your life miserable. That SYI always recommend that homeowners have a good relationship with their HOA because you never know when you might need their help. And if you don't have a good relationship with them, they could make your life really difficult. Now, I've got a question for you. Do you rather have an HOA, or would you rather not have an HOA? I think HOAs are great because somebody else is taking care of the property, but I also understand how they can be a pain in the neck sometimes. If you enjoyed this video, please hit the thumbs up button. Also, if you're a Colorado resident, I would love to hear from you. Do you have an HOA? Do you live in a planned community? Now leave me a comment and let me know. I've been your host. Until next time, I hope you find this video interesting. And remember, don't mess with the HOA.